Lawsuits can be very complicating, and they're most definitely time-consuming, but they can equally be most definitely rewarding. However, most people don't realize what's involved in the filing of a lawsuit. There's a lot that goes on before the actual lawsuit is filed. When we determine that you have the facts and the legal basis to file that lawsuit, that's really when the hard work begins. And that's where your homework begins. We will be asking you to participate with us in gathering information. We're not interested in working with people, with clients who aren't interested in working with us. It's not going to be the type of situation where you come in and you dump off a box of documents and say, here. We don't work like that, and it's not in your best interest in any event for us to work like that. We will need you to do and work with us in gathering documents, assisting us in getting witness statements, and helping you to understand the area of the law. We'll be providing to you the law in the form of case law or the statute, so you can start to learn and understand what it is that we have to prove should we have to go to trial. But before we go to trial, the lawsuit has to be filed. And what happens after the lawsuit is called discovery. That's the discovery process. And in the discovery process, there are different ways for each side to learn the facts of the other side, to discover the information that the other side has in their possession. And that method is generally known as discovery, and the means by which we obtain discoverable evidence is through things such as interrogatories, written questions, and notices to produce documents, and subpoenas, and depositions. Depositions probably being the most important aspect of the discovery phase. And the deposition is sworn testimony under oath. You're not in a court of law, but the testimony has the same force and effect as if you were to give it in a court of law. Before we would even get to the deposition process, we would prepare you, or the witness in that case, the witnesses that we're allowed to speak to ethically, but we would prepare you in advance for the whole deposition process. That is the opportunity for the other attorney, the other side's attorney, to ask you a series of questions. So you see, all of that is involved in the discovery process. But we will be working together one by one, one-on-one rather, in obtaining honest, truthful responses, but skilled responses in order to assist us and to ascertain and to obtain the same kind of information from the other side in order to prove our case. And after we prove our case, or after we get enough information, both sides get enough information. Oftentimes what happens in employment cases, I would say about 90% of the time, the other side, the defense side, will file what's called a motion for summary judgment. That's a motion to dismiss your case. After all that hard work, the defense is going to want to dismiss your case. And a motion for summary judgment is inevitably made by the defense after the discovery period has concluded, and the defense will argue, in short order, shortening this for the purposes of our vlog, but the defense will argue to the judge that here are the facts, judge, and according to the plaintiff, the employee's set of facts, they just don't meet the required elements under the law, and so therefore, judge, you shouldn't allow these set of facts to be decided by a jury. You, judge, can decide this set of facts based upon these elements of under the law, and since the plaintiff doesn't meet those elements under the law, you have to dismiss their case. And our job is to argue just the opposite, that, judge, under these set of facts, we most certainly meet this element or these elements of the law. And because employment law and civil rights law is ever evolving, it's changing, we have to be on top of those changes. We have to closely scrutinize the Supreme Court decisions, the Superior Court decisions, the Appellate Court decisions, and any legislative changes that are being made in the area of the law for employee protection. And we argue to the judge that our case certainly does meet the legal elements. If we survive the motion for summary judgment, then the next step is trial. Oftentimes, however, in employment and civil rights matters, before you even get to trial, there are various alternative dispute mechanisms that are available, and they are called arbitrations or mediations. And in our state, New Jersey, oftentimes these cases are required to be sent to mandatory mediation. Now, mediation is not binding. It's mandatory, that is, we're required to attend the mediation, but the mediator isn't the jury or the judge. The mediator is a person who effectively attempts to settle the case by facilitating, by explaining to both parties the weaknesses and the strengths of the case, and then hopefully in doing so, assist the parties in attempting to resolve the case. And most times it's in everyone's best interest to settle a case because it eliminates risks. Anytime you go to trial, either side, there's a risk. You never know what the jury will do. You don't know how witnesses will hold up in court under oath. It's virtually impossible to predict the outcome of trial. But if we get to trial, that's a subject matter for a whole other vlog. But if you get to trial, then you need to be prepared. And that takes a lot of effort, a lot of resources, and a lot of time.